Okay, so thank you for attending today's webinar. We are going to explore very fantastic topics about strategy and financing for patent lawsuit. So today's webinar will be include three speakers, very expert in this field. And we have Stephen Cho and Josh Mars and me, Alex Lee. So after my introduction, Steve will talk about winning patent litigation strategy, and followed by the Josh Mars about financing patent litigation. And I'm going to talk about evolving landscape of patent litigation. Particularly, I will talk about connected vehicles use cases. So today's webinar will be recorded and then will share, and then some presentation will be shared after our event. Okay, so without any delay, I will pass over to first speaker, Steve, to talk about his topic. So first, I will start my sharing. Steve, you can share your slide and you can start now. And during the talk, if you have any question, and then you can leave your question in the chat window, or after the session, we will have if you have a time left, we'll have additional Q&A time.
Well, good day. I'm happy to be here with you today. I've been at this for 48 years now, before my first patent suit on the IBM side of Xerox versus IBM. And I've been gone through a lot of the swings of the pendulum in both patents and in other intellectual property. Let's, excuse me. To define what a patent litigation is and what is a win, we look at what the property value of United States patents are, which is by statute a grant of rights to exclude other people from making, using, selling, offering to sell, or importing the invention that's claimed and granted by the U.S. Patent and Trademark Office. And this is something that at various times, and perhaps more importantly today, people have talked about. This is simply a license to sue, and the suit is very expensive. This was diminished in some way by the 2006 eBay case that changed the prior presumption of a grant of an injunction. So this is the idea that, well, how do you exclude other people if you don't enjoin them? And this permeated a lot of what has changed over the decades. But we also look at competition and strategic value. People look at this getting patents as a barrier to entry, as some way that you can get a head start on other people while you're trying to develop your technology. It's also a marketing credential that people say, well, gee, I have this patented thing and this looks good on the market. To some extent, there's an enforcement reputation that, if I have a patent and I enforce it, then other people are going to be scared about the big kid on the block and that kind of thing. But more importantly, also, is the freedom to operate, to quietly enjoy what you're doing without someone else suing you or disputing what you have, and even trading some of your patents for other people's patents. And then on top of this, maybe setting standards, or you may have a group of people, a group of entities that are trying to develop a standard for, let's say, video formats and things like that. And you may be doing your patent is valuable as part of that pool. But today, much of what we're talking about is monetization. So this is often the recovery of investments, sometimes for discontinued research. People started off and didn't get far enough for whatever reason, or companies, established companies, getting rid of their product lines and trying to recover some value from them. And the spectrum of dispute resolution goes from negotiation between the parties, typically of a license, and then to a mediation, where it is a mediation of some neutral. These mediations may involve what we call facilitative, The mediator attempts to match the interest. So you come up with a win-win. The mediator looks at what's most important to either side, and sometimes you can find something where certain adversarial aspects are more valuable to one side than the other, and you can optimize some kind of result. Or it can be evaluative, and where the mediator sort of evaluates objectively, saying, well, if you go forward with a lawsuit, here are your chances, and people may look at this as more objective. There is arbitration by a private neutral under agreed rules. A small example of that is the Amazon Patent Evaluation Express. Some people use to say, well, I see this infringing product on Amazon, and I challenge you to go into this proceeding, and you should abide by this proceeding. And that the success of that has been slow. On a much larger scale are the international arbitration of standards essential patents, and we see big fights on this. We're talking about billions of dollars, but we're talking about entire nations supporting their own views of what is standard essential and what should be licensed. But then what we're talking about mostly here today is the litigation inter partes, between parties in administrative agencies or courts. And there are other agency possibilities, for example, ex parte re-examination in the patent office, or we call in rem, that is against products in the ITC. So these are the forums that are important to people. District courts is where most patent infringement cases happen, because that's exclusively where it should happen, except for the ITC and the Court of Claims with respect to claims against the government. So the claim may be for patent infringement or for declaratory judgment that says that, well, I don't infringe, or this patent's invalid. However, because of our Constitution, there is standing required. So you have to be a real party in interest, and the patent owner, not a licensee, and even an exclusive licensee needs to perhaps get the input of the patent owner. Otherwise, you have a lot of standing questions that may be litigated. And there has been actual controversy. So sometimes the declaratory judgment doesn't have a controversy that rises to the level of a district court. If jurisdiction allows, that is, you have personal jurisdiction in a court, you may try to select the speed. We call some of these rocket dockets. Famous ones have been the Eastern District of Virginia and the Western and Eastern Districts of Texas have moved things very quickly, and that's one reason plaintiffs often want to go to them. Defendants often want to delay things for wait out the plaintiffs. Now, the experience of judges in particular patent cases, and the Texas, I should mention Delaware is also one of the places that of some choice, as well as the Northern District of California. In my own jurisdiction, District of Massachusetts is trying to get into this game as well. But some judges love patent cases. Many judges in the past hated them. Then you assess the jury pool, or you a home player. And then recent views on litigation finance. The one that I mentioned is Delaware. Delaware seems to be showing some resistance to the litigation finance side, and that is in the background. Now, what goes on in a lot of this is the resort to the Patent Trial and Appeal Board. This is the America Invents Act invalidation proceedings, because the reality is that the Congress was persuaded that there were patent non-practicing entities, sometimes called patent trolls, and that they wanted to get clean up the patent system, patent docket, let's say, and made it a little bit easier to invalidate patents. These proceedings are maybe co-pending with the district court proceeding if it's brought within 1 year of the complaint. the standard of proof is lower. It is a preponderance of the evidence versus clear and convincing evidence to invalidate a patent in court. There may be, generally, there are inter partes reviews, but they're based upon new evidence or evidence using patents and printed publications. Whereas the post-grant review, which was a bit of a compromise of the European approach, allowed for within 9 months of the issuance of patent to challenge on all grounds, challenge not only on the patents and printed publications as prior art, but also on the formality, disclosure, and that kind of thing. The International Trade Commission, I should mention, under Section 337, is different because it protects the objective is to protect U.S. industry against unfair importation practices, and that may be importation of patent infringing articles, and mostly 337 cases are that. There may be trade secret cases, occasionally a copyright case. For patent infringement, unlike some of the other unfair importation practices, requires a showing of a relevant domestic industry, but not actual injury as in other violations. Now, this acts what we call in rem, that is against articles and exclusion orders, saying that articles of this description may not enter the United States, and cease and desist orders that go to tracking down those articles that are in the United States. What this means is that unlike the district courts where we looked at personal jurisdiction against the party, the fact is that once these investigations go forward, that those parties may or may not come in, but if they don't come in and don't answer, don't participate, the articles may be attacked, and that goes to a lot of important things, like track down the parties and try to serve them in district court, discovering disputes that simply say, well, fine, you can come and defend or not. If you don't defend, we can simply go against these described articles. Now, however, there are no damages or counterclaims, but this also means that to some extent it may be a little more difficult to finance on an investment basis, but not necessarily, that's not impossible. But a lot of times, and I've dealt with smaller cases in over the decades, where the investigation by the U.S. government in starting an investigation sounds so bad that smaller players often do back down, and they'll negotiate a license or just get out the market. Of course, the U.S. Court of Appeals to the Federal Circuit is where the appeals go, both for district court, PTAB, and the U.S. ITC. Sometimes a party is lost in district court on an important issue, will agree to some sort of final judgment, which allows the discretionary appeal to the Federal Circuit. Now, what is winning? Remedies are a temporary restraining order or preliminary injunction. Is very rare in patents these days, but it requires the threat of imminent irreparable injury, showing of likelihood of success, and a balance of injury. This is more common in former employee trade secret cases, which are sometimes tied with patent cases. And then originally there was the permanent injunction, and this is what's called an equitable remedy. That is, the court decides to balance things. However, the eBay case in 2006 changed that enormously by saying that you no longer have a presumption of getting an injunction after finding infringement. And it used to be that we would get close to, and I could represent small mom and pop manufacturing people, $5 million in annual revenues in the 1990s, and we would spend a few $100,000 getting to the point where we could get a summary judgment that is deciding some issues that, we don't really need to go to trial to find that you infringe, that as soon as we got to that point, the threat of a threat of an injunction would often force a settlement at that point. Today, the issue is that you don't have that presumption. Then you have to go through the whole process and show damages, and even if you get an injunction, it may get appealed. Really, the landscape has changed tremendously because of the eBay case. However, the US ITC allows a different type of injunction. Again, these exclusion orders against the articles. There may be a general exclusion order against all things of that description, or limited, and this is more often the case, against the respondent. Again, this is what are parts of winning on a certain side. However, damages are what often is what people are looking for in terms of direct investment in a patent suit. These are direct damages for profits lost by the patent owner to infringement, including diversion of sales or price erosion. However, in the situation where the plaintiff, the patent owner plaintiff, has left the commerce, or has not yet really developed a industry, let's say, or just their own deployment of the patent, there may be imputed damages, that these are called reasonable royalties, and they're measured today by hypothetical negotiation between a willing licensor and licensee, which is a very arcane discussion, and generally is evidenced by comparable licenses, and experts come in and talk about whether they're comparable licenses or not. But it's very difficult where there are no licenses to begin with. Now, the analytical approach, the old days, we used to say that a 5% is a reasonable royalty because that's 1/3 of what the average margin is in manufacturing. So manufacturing margins used to be 15% for many decades. And then we wound up in the 1990s and offshoring a lot of manufacturing, partly because of the low 15% was not considered to be an adequate margin for large companies. So that happened in the 1990s, basically. A restitution that's unjust enrichment. The other side made a lot of money on your patent. That's not really available for patents. It's found somehow in the reasonable royalties. There are exemplary damages. These are triple damages. In theory, very, very unlikely to happen, usually because of some procedural abuse. And this is also for attorney's fees. In the American rule, each party pays its own fees, but there is a discretionary award, not that common. So just generally to help people understand a little bit of what to expect, and part of the strategy is to really understand the market in the channels of distribution, the choke points, jurisdiction, whether you can get personal jurisdiction, or you have to go in rem, perhaps an ITC, potential remedies, the ones that are winning the things that we've talked about, and what are advantageous forms and timing. We really do need to interview the inventors to uncover any defects or weaknesses, and to find supportable positions for infringement and validity arguments. And this is sometimes, I think, overlooked by especially firms that get a bit specialized. That is, people are there to try to invalidate the patent from the defense side, and they don't think about what the issues are with respect to infringement. So the issue, the general thought is that, well, if you have a broad patent, a broad interpretation of a patent, then that covers more infringing things. But on the other hand, if you have such a breadth of the claim, then you also bring in some prior art that may invalidate your patent. So often there's a balance between those two, and to understand how to interpret particular terms to get to that is very important. I think that is part of a winning strategy to start cases. And you try to find and lock up experts in this technology, including for the AI-aided inter-parties review proceedings, and defining the market, or even assessing what the market looks like, because sometimes you find that people don't disclose what the financials are, and you find too late that after sinking a lot of money into a case that well, they've moved all this stuff offshore. They've sold off the lines to some other entity, and well, you're really looking at a very small possibility of damages. So then the complaint and motions to dismiss, that's part of it. Some courts vary by specificity. But again, early infringement and invalidity contentions are required with courts with patent-specific rules along with claim construction. And this briefing requires a hearing, and this is often a settlement point. Discovery is the most expensive part. There is automatic discovery, and for those of you who don't know, the part of the process is interrogatories, questions to be answered on the oath to the other side, requests for production of documents, which is something that's really unique to the United States in many ways, but it's also been limited by court rules, and especially with the rise of electronic mail and other things like that. Depositions are very important. In the United States, it's a real-time questioning of an opposing or third-party witness on the oath. And this is for combined purposes of evincing some background information and location of other information, but stabilizing his witness's story for cross-examination at trial, which is often the most important part of a trial. There are special issues for source code, and in the future, use of generative AI. There is a trend that makes it a little bit more practical today to use remote rather than live depositions, and going to somewhere in Asia to a deposition and having local translators and that kind of thing. There are often concurrent AI proceedings. Some courts are more likely to stay their own proceedings, and the positions, particularly expert positions, need to be consistent. And this is, again, development and exchange of expert reports. Summary judgment is something that issues that be decided by the court's application of law, where there's an existing discovery shows that there's no material issue of fact to be tried, for example, by a jury. A decision often leads to settlement even after not having the eBay threat. Trial prep, I think these are just things that we talk about. That get to trial, you may have seen what's going on if you're following the New York trial at this point, you see a lot of those issues coming up. The cost of these things is that basically I put out a number of mean numbers, but we're talking about even when there's let's say $10 to $25 million at stake, just going through discovery maybe $1.5 million, and going through trial and appeal maybe close to $3 million. And ITC cases are even bigger, although I would say that there are possibilities of getting out very quickly with even less than a six-figure investment if the respondent caves in. IPRs and PGRs, these are AIA things. Just filing through the petition is an average of $233,000. Going through hearings, $600,000, going all the way through appeals, maybe $725,000. So what's the winning strategy? As an investment, it should be clear from the above that the return on the mean invested cost of litigation may be a poor investment, even for large businesses, unless the objectives are the competitive ones mentioned. These include establishing a reputation for enforcement or opposing holdups, or there's a possibility of negotiating settlements with licenses that other infringers at lower litigation costs, including by establishing a favorable reasonable royalty comparable. In the AIA proceedings, there may be portfolio battles. I've been involved in these where two competitors have large patent portfolios, and they want to pick off each other's portfolios for strategic reasons, or they want ultimately to position for either a technology space or for cross licensing. So all these things are mixed into what it means to be to win something. And the again, you look at the expense of litigation and weigh at what point you can get out and what you can get investment in. So in many cases, litigation financing possibilities exist. And one of the and Josh will go through some of these in particular at this point. So let's thank you for listening to this part and certainly entertain any questions.
Is there any question? Okay, so if you have any question, then you can leave your question in chat. Thanks, Steve. I think this is the most excellent insight and overview about patent litigation I ever seen. So thank you very much. Okay, so next speaker will be George. He's going to share his insight about fascinating topic about financing of patent litigation. George, it's now your turn.
Great. Thank you very much. Can everybody hear me okay? Good?
Yeah, good.
Okay. So I'm going to drop just a simple bulleted list into the chat, and that's just going to be the outline that I'm going to speak to, just to orient you. So it's really nice to spend this time with you. I'm happy to provide some background on some aspects of patent litigation funding that I think are either misunderstood or information that's less readily available. So I really want to focus on things that I think are particularly helpful as you think about developing a case or presenting a case to a litigation funder. In terms of my background, I've been working on patent-driven transactions really most of my career, ranging from spinning out patent portfolios from large companies into new ventures, to university technology transfer, to portfolio development and licensing. And most recently, I've been involved in litigation funding of all kinds, and patent litigation funding in particular. I had a role in starting two U.S. patent litigation funders, and I'm currently at a firm called Finitive, where we have a unique approach for certain IP-driven transactions, where we streamline them and make them ultimately make the market ultimately more scalable. So I'm going to focus on talking about litigation funding usage in patent cases. I'm going to focus on single case funding. That's the simplest implementation. I'm going to focus on single case kind of client side funding. Obviously, some of what I'm going to talk about can be relevant for portfolio funding or law firm side transactions. But I'm going to start with really a simple description of why litigation funding is particularly applicable to patent cases. And essentially, the reason is that these are the most complex, the most expensive. They have the most kind of expense intensity associated with experts. So it's the type of case where a risk-sharing partner is most applicable. And patent cases are also the type of case where the law firm is really the less well-suited to address all of the risks in the case. And in particular, the law firms are reticent to cover some of the out-of-pocket costs associated with experts and other vendors associated with litigation funding. So patent litigation funding tends to be a great fit for patent cases. And in terms of the value proposition for clients, you typically do have this David versus Goliath scenario where a smaller individual inventor or small company isn't really well suited to go up against a large, well-pocketed, deep-pocketed defendant. The funding may give the client a greater choice of law firms and experts. They may be able to access higher quality resources than they could access on their own. And in some cases, the client may use funding to access operating capital or other funds for working capital that is beneficial to them while they wait for the outcome of their case. And I think when you think about choosing a funder, I think there's a lot of focus on how funders pick cases. And I don't think there's as much focus on how patent owners and counsel should pick funders. And I think that's a really important part of the process, because ultimately the better fit a case is with a particular funder, there are a lot of benefits that might not be obvious at the outset. The process will go smoother, it will be faster, there'll be fewer surprises and unexpected outcomes at the end, and ultimately the pricing will ultimately be more realistic. And the reason I mention this is because there are many, many funders that claim to fund patent cases. And you can find a large set. And in actuality, the number of funders that have a track record, deep expertise funding patent cases, as well as the specialized diligence resources to evaluate these cases, is actually a fairly small set. So the first question that I normally suggest clients and law firms consider is, what is the subset of funders that should be reviewing this case? In my experience, it tends to be better to do some upfront research and identify a smaller core group of funders rather than take your valuable information about the case and your materials and send them broadly across the market. That's the first kind of piece of advice that I would say, is it's much better to really spend some time trying to match the case with a particular funder. And I think the other thing to keep in mind that's very, very important is, before you approach a funder, I think it's very important that everything kind of fits together from a funding proposal standpoint. And one of the key things that I would encourage you to think about is, what are you seeking funding for and why? Is it just costs? Is it fees plus costs? Is it fees plus costs plus working capital? And does that whole story fit together, particularly in light of the law firm? Some law firms are well suited for contingency work. Some law firms are simply not well suited for that, and they won't operate effectively under that model. So it's very important that if you want to think about it as like a business plan, like an entrepreneur would prepare a business plan and present that to a venture capitalist, it's very important that the client and the law firm kind of work together to prepare a proposal or a plan that fits together. And that's going to make the whole process a lot more efficient. In terms of attractive case characteristics, I just want to mention a couple things that are really important. And the whole focus of my comments is to help you navigate the process of approaching funders, responding to funders' questions, and ultimately having a good outcome in the process. The one thing I would start with is that funders are looking for focus. Focus is incredibly important. A funder is more interested in one good case that has been fully developed than 3 or 4 cases that are partially developed. They are interested in a strong story that holds together with respect to, infringement, validity, damages, budget around a particular case, as opposed to a discussion around the broad monetization potential of a portfolio. That's just one thing that I would definitely encourage people to think about, is based on how funders are set up and staffed, they are really designed to evaluate specific cases. They are less well suited to mine portfolios, to identify, a broader monetization, they're less well suited to identify or even appreciate a broader monetization strategy. So they're very interested in the monetization potential of a particular portfolio, but everything starts with a case that that holds together, withstands diligence, and ultimately that they can underwrite. So I think that's very important. I think the other thing that I would say is funders are looking for candor. They're not looking for a perfect riskless case. Those cases really aren't out there. So when you're approaching a funder, be aware of the weaknesses of the case and be prepared to discuss them. Or if there are things that will impact their diligence, things like security interests or liens or litigation or licensing history, prior actions or involvement of the key parties, including the inventors and co-inventors. All of these things are very, very important in helping the funder diligence the case efficiently and effectively, and ultimately develop confidence that they're working with a party that's forthcoming. It is far better to bring up less appealing, or it's far better to raise weaknesses or concerns rather than have the funder raise them on their own through their diligence process. So that is another piece of advice. In terms of the types of cases that funders like, obviously I don't speak for all funders. We have a very unique program that funds high value complex patent litigation. We look for certain characteristics or eligibility criteria. We look for multiple patents or a portfolio. We look for multiple defendants. However, we focus on a key initial case that we seek to understand in a lot of detail. We look for realistic damages that are of a certain level, and we also look for a third-party damages report that corroborates or stress tests some of the key assumptions. We're looking for alignment between the inventor's story, their history, their story, and the case that they're seeking to pursue. We're not looking for, funders are not looking for, nothing a funder does and no capital a funder would commit turns a marginal case into a strong case. We're looking for good cases that are meritorious, where the patent owner has a compelling story and narrative that is consistent with the merits of the case that we're seeking to underwrite. I guess a couple other things that I would talk about briefly. I talked about the fact that it's helpful to have a third-party damages report. This doesn't have to be something expansive or expensive. It's just helpful as a test, as an objective kind of test of the key assumptions. Venue is incredibly important. When we look at a funding memo, we look for a very thoughtful early discussion of venue, because a lot of the other elements of our underwriting will flow from venue, and not just venue where the case will be filed, but venue where the case will ultimately stay. I don't mean stay in a technical sense. I mean remain, as opposed to being transferred. So that's also really, really important. I think that we look for a really strong linkage between the case that's being made on infringement, the validity profile, and the file history of the patents, as well as the damages. And we ultimately look for those linkages to be very consistent. And the reason that I mentioned very consistent is because I would also submit that when you're approaching a funder to have the maximum effectiveness, the materials should really be, if not prepared, they should certainly be signed off on by the ultimate counsel that's going to litigate the case. And I just think that's a very important. We see a lot of cases where it's just being driven by the client, and some of the clients are incredibly sophisticated, and we're happy to interact with them. But ultimately, this is an investment that's very tied to the expertise, the experience, and the skills of the firm that's going to be litigating the case. So I think what you'll tend to find is that a funder can get an opportunity to a certain point, but they can't progress it beyond that point unless the law firm that's going to pursue the case is actually in place and has prepared or really fundamentally signed off on the materials. You know, in terms of just other other I got a data point that someone can't see my bullet points. Are you able to see my bullet points? Background.
Mm-hmm.
I'll just put them through again. William, I just sent it through to you. Sorry about that. Not sure why.
Yeah, I can see in
Um,
chat the
okay,
background and objective,
okay.
the litigation funding use in case. Yeah.
So in terms of review and closing processes and hard questions to ask funders, like you should, my advice is you should be asking the funders a lot of questions as well. Some funders look like funders, but they're actually intermediaries and they don't have the capital behind their program. Others don't have the depth of expertise or the range of expertise to effectively diligence patent cases. So it's very important to ask them a lot of questions. And I think one of the key things that's important to understand as you approach funders, and again, my objective is to help you navigate this process effectively. It's very important to understand the relationship between the term sheet and the diligence period and the ultimate funding agreement. So it's very, very important to understand that when you get a term sheet, is that binding? Is that non-binding? Will those terms change after diligence? Are they likely to change after diligence? And just how the mechanics of the diligence period actually work. There are a lot, I'm happy to go into more detail, but there are a lot of things that are important to understand that only come from experience, that only come from just being through this process a number of times. So I think that's very important. It's important to really see the final funding agreement. We have a unique program where our terms are standardized, our docs are standardized, which creates more certainty around the closing of these deals. I think that's very important. Ultimately, I think that, you know, there are some other aspects that I would, you know, encourage you to think about. What are the clauses around termination? How does what are the mechanisms through which a funder can terminate a funding agreement? How does the security interest work around the intellectual property that's going to be the collateral, so to speak, in the funding agreement is very important. Who are the signatories to the agreement is very important and can vary dramatically from funder to funder. And I also think it's also important to understand the funding mechanism. Many funders will not kind of fully fund a case at the outset. They will drip out the funding. And this is an important thing to understand. Other funders fully fund the case, which is attractive from the standpoint of the law firm and the client because it's a much more substantial commitment. So those are just some things to think about. I'm going to pause here. There's plenty of more to talk about. We can get into all kinds of topics, but I wanted to pause here just to see if there are any questions or if there are particular topics that you wanted me to get into. And, you know, just let me know what would be most helpful. But ultimately, I guess if I was summarizing, ultimately, I think it's very important to, you know, prepare the proposal so that the pieces fit together. The overall story includes the strengths and the weaknesses of the case, and that there's buy-in and sign-off from a credible law firm, including the economic terms and the budget. And then I just think it's very important to try and narrow down the list, narrow down the landscape of funders to the few that are really sophisticated and experienced in doing patent cases, because this is not for, you don't want to be the first patent case for a particular funder. And you might not know that going in. So it's very, very, they may have looked at a lot of patent cases, but you may be the first patent case they fund, and that's not a place you want to be. So why don't I pause there? I hope that's helpful. I appreciate the chance to chat with everybody.
Thank you, George. I think that it's very rare to share something about the relation financing. And I think that this is a good opportunity to let other people, because last year actually I contacted a lot of the patent owners to explain about the relation financing. They never ever heard of relation financing. So I think that it's good time to let other people know about this opportunity. And then that'll be my duty actually after this webinar. I'm going to share this valuable information to anyone that I know about in the related patent relation. Thank you very much, George.
My
Okay,
pleasure.
so I'll be the final speaker. So we have only about 10 minutes, but I can talk very quickly. And then I also get some questions about this. Okay, so George, how about leaving your contact points if the audience have some question to you, then they can contact you directly. Yeah.
Yeah, if it's okay, I'll drop my email in the chat, and
Yeah.
I'm totally happy to answer questions. And to be honest with you, I do this a lot. If something's not a fit for us, but I can be helpful, I'm happy to make introductions and point people in the right direction, because ultimately I want good cases to be handled more carefully. So happy to help.
Okay, so my topic is evolving landscape of patent litigation, and particularly I'm going to focus on connected vehicles. So for me, I have a little bit different career path to compare to Steve. He has very expertise and really focus on in patent area and litigation and in all the aspect of IP area. After maybe he had a science degree and engineering degree, but for me, I did the career path to be a professor. So I did my PhD, and then I have a short time staying in the university as a professor, and then move into industry. But that's a Korean government. Actually, I was some of the government officer related to the emerging technology. At the time, the emerging technology of mobile communication. So I contribute to the deployment of 2G mobile communication in South Korea. So now they're going to 6G. So you will think about that was 30 years ago. And then after that, I've been in industry, usually that we call high-tech industry. So I through all the IT, telecom, semiconductor, electronics, and then recently all the digital, big data, AI, blockchain, IoT, whatever. So I was a forefront in all the emerging technology areas. So I know about how the innovation is going on and how they grown into the market and what some successful and not. And in parallel with actually by some reason I attended law school, and then I'm a lawyer now. But my way to doing my business is not particularly not only purely focused on a legal side, but I'm also an innovation side. So I'm in a good position to talk about what happened, all the emerging technology innovation, and then all the innovation actually that we mean have accompanying patents, and then how they end up being litigation. I know about all the history, and okay, so I will start shortly about because why I focus on today connected vehicle is I think that this is a current focus. What I mean by the current focus is that my experience is wide IP. Actually, my first involvement IP was actually I was at the time was very expertise in industry in high tech, and then about business strategy. I'm consulting a lot of big companies about the how to do is emerging technology business. So I hired by IP law firm. I actually there's a IP consulting on that law firm. And then my position was a strategy advisor to developing new strategy business in IP. And then I found that what's the problem with IP, particularly patent. A lot of people don't think about patent can be make money, right? A lot of people think about patent is very important in accompanying actually like a byproduct, whatever, some deliberately developing patents, but they cannot recognize what real value of the patent. Usually, a lot of people express that oh, patent is essential, but they don't think of it as a business, is very good business value or something like that. So at the time, I'm very interested in how actually patent can make money, right? And then I found that this space, like a patent can be monetized, either licensed peacefully, and unpeacefully means that through the litigation. In some cases, actually, the litigation space is by the competitors, so between the operation company, but most of the like notorious women, like notorious means that we know in the media is filed by the we call patent association entities, right? So these patent association entities actually acquire patent and then they litigate for some money, right? And otherwise, another company like Nokia, Ericsson, they are very good, very big countries like Qualcomm contribute to mobile communication innovation, but usually this technology that is a standard, the way to in the public domain. That means that they organize a meeting. And when I was South Korea as a Korean government, actually I delegate to the ITU or other ETSI, and then we discuss about how to standardize of the new technologies. I've been in the contributing 3Z and when I was in South Korea. And after that, I worked on the 4Z up to that point. And after the 5Z, actually, I never worked for the in detail, but I know about I tracked down all the 5Z, 6G and other technology. And then this kind of Nokia, Ericsson, Qualcomm, actually, they are the aggressively utilizing patent for the licensing. So some case actually if there is no physical licensing, actually they insisted through the patent litigation. So this is one space. And the other things that I'm thinking about is the why focus, because until a certain time that something happened. Something happened means a very, very grand scale issue in IP. People are not really interested in patent. So for example, I mean the old good day for me, I was very, very, very excited and I participated actively in patent and monetization and licensing litigation space was back to early stage of a smartphone show in the market by the Apple launched new smartphone and then it's market growing. There was a big debate between the Samsung and Apple, Nokia, everybody, the war, and then we call smartphone patent wars. And then I work in behind because recently I contacted some people who are interested in hire me to acquire some patents, but then and then I explained my background actually that I work in background all the big deals like Nokia, for example, Notel bankruptcy, Notel deals and the Motorola deals, and after that actually I worked with a lot of company to acquire patent and then I see that a lot of the patent actually that contribute behind actually I seen they are now in the litigation, right? So I explained my background and then I seen all the how happened from the starting of the innovation and there was patent and then there will be the market and market growing and then finally end up being litigation. So this kind of connected vehicle is a time because I will explain shortly later that when I attended law school, actually the hot topic was I mentioned about the patent litigation and related at the time litigation was the 4G LTE standard asset patents. So I wrote my thesis about what is a friend licensing and how go about how to decide licensing a royalty rate something like that. And then after I graduate, I shortly published my concern about it will be moving to connected car licensing deals in the how to friend. It was 10 years ago. And then after 10 years later that I concerned about, I foresee 10 years before that this will be a issue and the challenge in the market in after 10 years. So this kind of thing that happened, for example, Nokia and Daimler is an automotive a manufacturer. And then the one way actually to avoid is a patent fools and Avanci producer like Avanci is founded by I don't know about it. He might be the Ericsson former Ericsson CIPO, and then he launched the patent for the cross licensing for this kind of the wireless technology for the connected vehicles, and then But the problem with the patent pool is that because there are many companies out there that joining patent pool, and then they assertion their own patents. We call patent assertion entities. And then these patent and assertion entities actually, they acquire patent from the third party. And then I've seen that, for example, in the like a connected vehicle space, actually the JERA research and development, this company actually acquired a lot of this kind of like what we call B2B communication system related to connected vehicle. And then, for example, they acquire a lot of people, content, a lot of patents in Intel, and then they sue a lot of company already. And then they're looking for like, for example, like a demand for license fees. And then, so this is the one actually we should look at it in this space. It's the same thing was happening before, that there was an issue about like weaker patent tools when there was a boom of the smartphone, and actually that's of some reason. There is a one key reason actually that we have an AIA new patent law by Obama, because of they want protect industry from this kind of patent association entities. And so, for example, in the Europe, actually, they know about this problem in this industry. They propose a new law about like some new friend licensing royalty, and there was a debate about the operating company like manufacturers and their vendors, and then IP like big IP giant Nokia, Ericsson, Qualcomm. About debate is still going on. But anyway, this is the hot like patent relation workspace actually, that all the like patent rate like the connected vehicle, especially for the standardized patent for the connectivity, and then big companies for the patent pool, and then the manufacturers, and then patent association entities coexist and interplay for this space. So this change will be evolving to the other space also. I can imagine that I will give you some answer about some people ask about what is happening in the AI, because I'm aggressively also innovating AI, and last year I have a lot of researches about the IP related to AI. Then I can expect what will happen in the future about AI. So this is one actually I mentioned that after I graduate, actually the base of my thesis, I worry about what will happen like a LT pattern about the connected car. At this time, actually, I made the first man actually to ever notice it will be happening in the future. So it is 10 years ago, and then now it's happening again. Okay, so we analyzed to look at what the pattern landscape or connected vehicles. We have intense analyze. I work with my business partner about we analyze all over like a 30 more than 30,000 patents, and then we like divided by the technology, and we analyze everything. So we find out what the key like innovator in this space, and then here is the final thing that I noticed. What usually this is what I'm doing is for the industry, that for the connected car vehicles, that we look at what with the patent relation landscape expectation. So usually what I'm doing is counting the patents owned by some like, so for example, like owned by the like a big like association company, like operating company, Qualcomm, Ericsson, Nokia will be one way. But I think that but they usually go over like a patent first. So usually for the moderate risk case, actually I count the owned by the individual owners, or we call MP or patent association entity. So for the overall like more than 30,000 patent related connected vehicles, we found that you see that this is a normal operation company, about 76%. So at least more than 20% actually is highly probably provide the potential of litigation can be used in the litigation. So this connected car space is in a risk factors is very high. And particularly with my business partner, we look at some specific patterns actually that we do evidence use analysis. So we can conclude that some pattern actually can actually infringed by the commercial product at the market. And then we counted that the total number infringed patent is 254. And then we found that the owned by the individual is 11, is 4%. And the owned by the patent association entities is 21%. It's a very similar number, right? So even we analyze in the deep dive, we found that about 20% is a potential can be used. And I found that some of the patent actually that we found in the blind test, and then to look at it and then whether they are used in the litigation actually, we found that several actually used in the litigation. So we are very confident about that. This space will be very like highly risk in the patent litigation. So yeah, so you can judge that if you are in this space, you should be prepare about how to protect your like product, or you may need like for instance Steve's like insight about how to do in the winning patent strategy. In some cases, you need to find out the financing, like George talked about it. Okay, so final thought, because we already passed one. Final thought that I will start my sharing that final thought about, because people are interested in the AI. Because last year, by some reason, I was looking for, because I want to back to IP space again last year by some reason. And then I tried to find out what will be the issue, what is the big issue that I have experience in smartphone when more than 10 years back. And I found that AI, especially we call large language models, right? We call like a ChatGPT, right? Because so last year was a hot issue in AI was ChatGPT, like large language model. So I'm looking at whether there is a possibility of the relation, and I look at the technical details about the ChatGPT. I know about the like structure, and then I look at who might have a patent about that. I found that Google. And then I did the infringement analysis. They completely infringe patents of Google. But you know that Google is a founding like innovator in ChatGPT like LMS. But I posted my site about let them know that because there will be a AI world in the near future. See that here is a ChatGPT compared to Google and the infringing. I saw that many AI product actually infringing some patents, and I found that. But actually, what I've seen is somewhat different. This is a software space, and I found that the way actually the acting in the software industry is somewhat different that I found. But in certain time that I mentioned, require time, because I mentioned that, for example, that connected car vehicles, fundamental technology, wireless communication, and we call IoT. That for example, origin of the IoT was back to 99 in the MIT Altai lab. Actually, that I worked for the space at the time. After 10 years later, there was a boom about the IoT. And then after 10 years, there was a dispute. So usually there is a migration, and then there was a mature market, and what the pattern formulate of in relation to that kind of industry ecosystem. So AI might be some way, not now, but maybe in the near future, will be at the core of the patent dispute. But I can imagine it's not right now, but maybe in a few years later. And then so my final maybe provide you some insight about that, actually why that people are not see the IP in the value, because I've seen that. I've seen that recently I working in the healthcare industry, and then I try to let people patent are very important, and then a lot of people actually think about it. Oh, okay, so filing patent is essential, but not necessarily for the business. But I've seen that they only show up their value when they're bankrupt. That I've seen the Notaire, and recently there were several bankrupt already in the digital healthcare, and then they are acquired by the other company or the IP company, or so. So the reason is that they are behind some value of the operation product or not. But if that kind of removed, like for example, hidden is removed, the IP will show up, and then they will be actively used in the litigations. So I think that the AI will follow the same track in the near future. If something happen in the industry, then what will happen? IP will show up, and there will be a lot of AI litigation that I expected. Okay, so thank you. Already past 7 minutes, 3 about that. So I'm going to share the record with you, and then if you have any question, then you can ask the individual speakers. And also, like we're going to share the presentation. And Josh, if you have anything to share, then just let me know. Then I'll share to the older, like people. A lot of people actually cannot join today, but we have more than 130 participants. So I'm going to share that because your topic is really, really important, and Steve's topic, I think that is an excellent like have an overview and the insight about the patent litigation. So I want to share to everyone in this space. Okay,
Thank you very
so
much.
thank you for attending today's webinar, and then thank you, George and Steve and everybody, and have a nice day. Thank you.
Thank you.